Hi friend, welcome to the Company Law Update. Today we are discussing Company Law Committee Report 2022. This report is invited for the suggestion or comments from the professional or a stakeholder to e-consultation platform on the MCA website. This is posted on the 12th April 2022. Report of the Company Law Committee. It recommends various changes in the Companies Act to recognize a new concept, expedite corporate processes, and improve compliance requirement. And to some extent, is removing ambiguities from the existing provision. It also suggests some changes in the LLP Act to enable producer companies to organization to incorporate under the LLP Act. MCA has constituted this committee to make recommendation to the government for changes for promoting greater ease of the doing business in India and effective implementation of the Companies Act 2013 and LLP Act 2008 and rules made thereunder. Committee has submitted its latest report 2022 to the government on the 21st March 2022, which has placed on the website of the MCA and decided to invite comments, suggestion to said report to all stakeholders through e-consultation platform on the MCA website. Therefore, it is requested that comments or suggestions on the report may be provided to such facility by 6th May 2022. That is the last date of the submission of your suggestion or comment. That is the 6th May 2022. Comments or suggestion should be with a specific reference to one or more paragraphs of the report of the CLC and should be submitted to the online facility only. Suggestion which is not related to the paragraph will not be taken on record. So in order to avoid repetition or duplication of the comment suggestion, the members or professionals of the professional institute or council industry chambers should route their comment suggestion through their respective institute, council or chambers also. Let's see the points covered under the report of the Company Law Committee. Let's see the table, which is recommends the main recommendation and observation and recommendation of the committee and proposed amendment in the Companies Act 2013. First main recommendation is the allowing company to realign their financial year. Dear friend, in this the company that which is ceased to be associated with the foreign entity. This is ceased to be associated with the foreign entity should empower a fresh application with the central government to prescribed form to allow them to revert to the financial year followed in India. In the Companies Act 2013, there is the financial year which is defined as the starting from the 1st April and ending with the 31st March of the next year, except first financial year in case of the company incorporated on and after 31st December. Then in case of the foreign companies, Indian company associate of the foreign companies as a subsidiary or holding company, so then in that case the consolidation of the accounts is also required. So for this purpose, to promote ease of the doing business and simplifying compliances, the committee proposed that such company which ceased to be associated with a foreign company should be allowed to file a fresh application with the central government in prescribed form to allow them to revert back to the financial year followed under the Companies Act 2013. In this regard, there is amendment proposed in section 2, clause 41 to permit companies to realign their financial year where they cease to be associated with the foreign entities subject to an application to the central government. Second, facilitating communication in electronic form. Certain companies should be mandated to serve certain document in electronic mode only. The fees borne by a company members while requesting such document may be determined at any general meeting of the company. Postal delivery of the documents should remain available where members have specifically requested to receive such document also physical form. Therefore, this is proposed changes in the Companies Act, that the amendment to section 20 of the Companies Act, which introduced an overriding provision enabling central government to prescribe rules for the classes of the companies. This is mandatory required to serve certain document in electronic mode only. There is also amendment proposed in the provisos to section 20 subsection 2 to allow companies to stipulate the concern fee at any general meeting. Next recommendation, recognizing issuance and holding of the fractional share and restricted stock units and a stock appreciation right. For this purpose, there is the insertion of a section in chapter 4 to permit issuance, holding, transfer of equity share less than 1 unit for the prescribed classes of the companies. Also, amendments proposed in section 62 subsection 1 to allow additional employees compensation scheme linked to the value of the share capital of a company. There is also a recommendation of the easing the requirement of raising capital in distressed company. That is for the revival of the company. This provision is should be amended. Distressed companies should be allowed to issue share at a discount, notwithstanding the provision under section 53 of the Companies Act. You check the provision of section 53 where it is a provision mentioned on the issue of the share at discount. So whatever say section 53, but overriding provision, that is the notwithstanding the no provision under section 53 of the Companies Act, distressed companies should be allowed to issue share at a discount. For this purpose, distressed company may be categorized as such class or classes of the companies as prescribed by the central government. For this purpose, proposed amendment in section 53 subsection 2A to permit distressed company to issue share at a discount in such manner as may be prescribed, notwithstanding the provision under section 53 subsection 1 of the Companies Act. Replacing affidavit with self-declaration. This is the self-regulation. The requirement of furnishing affidavit should be replaced with filing a declaration under the provision of Companies Act and rules made thereunder, except those provisions involving filing affidavit before NCLT, NCLAT, and regional director. The central government may prescribe format for filing such declaration. There is an amendment in section 68 subsection 6 of the Companies Act to permit a company to file self-declaration in a place of an affidavit where purchasing its own shares, and other sections, section 374 clause C, to permit a company to file a self-declaration in place of an affidavit where seeking registration under part 1 of the chapter 21. Here is the list given in the column D. There is the also changes in the rules 7 sub rule 4.1 of the company incorporation rule, where a company applying to convert it to one-person company must apply to for the ROC in prescribed form. Such an application is required to a company by affidavit from the company director confirming all the members and creditors of the company have give their consent converting one-person company. And other provision which is listed on the report in full report. There is the also clarifying provision on the buyback of the securities. There is the amendment in proviso to section 68 subsection 2 to explicitly include fees while calculating the threshold of the 25% in case of the buyback of the equity shares. An amendment to the explanation to section 68 clarifying that only those stock options which has been exercised can be bought back by the company. A specific provision on the inclusion of the trust on the register of the member. There is a new section insertion that is specially prohibit companies from entering a notice of any trust expressed, implied, or constructive on their register of the members. There is a provision of holding general meeting through the use of the technology. Companies Act should enable companies to hold general meeting, AGM, EGM, physically, virtually, and hybrid mode, where the meeting is to be conducted entirely in the electronic mode. Notice period of such meetings should be reduced to such period as may be prescribed by the central government. Accordingly, amendment proposed in section 96 of the Companies Act to enable companies to hold AGM in electronic mode in such manner as may be prescribed. Further amendment to section 100 to enable companies to hold AGM in electronic mode in such manner as may be prescribed, and insertion of a proviso in section 101 of the Companies Act to provide general meeting held in electronic mode may be called by giving such notice as may be prescribed. Further, maintaining a statutory register to an electronic platform. Certain companies should be required to be mandatory maintain their register on an electronic platform in the manner laid down by the central government. For this purpose, the central government set up an electronic facility. The central government may direct the companies to share the information held on such a statutory register pursuant to certain enforcement related functions. There is an amendment in section 120 to mandate that prescribed class or classes of company to maintain register on an electronic facility provided by the central government. Central government may be allowed to direct the companies to share information held on a statutory register in certain enforcement related functions. Further, there is changes in the EPF, Investor Education and Protection Fund, related changes in the section 124 to 125 of the Companies Act, and there is the strengthening National Financial Reporting Authority, which is the NFRA, should be empowered to take appropriate action against the auditor for non-compliance with the Companies Act and requirement thereunder that do not qualify as a professional or other misconduct. There is an amendment proposed in section 132 of the Companies Act that will provide NFRA chairperson shall have the power of the general superintendent's direction and control regarding all administrative matter of the authority, and empowering NFRA to take action against the auditor for the non-compliance with the Companies Act and requirement thereunder that do not qualify as the professional or other misconduct. Additionally, empower NFRA to take appropriate penal action if its order are not complied with. There is the strengthening the NFRA authority, or there is a strengthening the audit framework. This is the very important amendment suggested by the Company Law Committee report. Companies Act should enable the central government to prescribe a differential list of the provision on availing non-audit services for certain classes of the companies. This is also included as increasing central government may prescribe other list of the non-audit services provided under the Companies Act. Section 147 should be amended to cover penal consequences for contravention of subsections 143 other than subsection 12. Further, a resigning director should be under an explicit obligation to make detailed disclosure before resignation, and should specifically mention that such resignation is due to non-cooperation from the client company, fraud or severe non-compliances or diversion of the fund. Moreover, if such information come to the light after the resignation of the auditor, but has not been disclosed in the resignation statement, suitable action may be taken against the resigning director. Additionally, the auditor should be mandated to provide assurance about the company accounts and independence of her decision to resign. The Companies Act should be enable central government to mandate joint audit for the such classes of the companies as may be deemed necessary, and Companies Act should enable the central government to order forensic audit in cases of investigation under Chapter 14 in such manner as may be prescribed. So this is the proposed recommendation of the on strengthening the audit framework. Further, standardizing qualification by the auditor. There should be a format for the auditor to provide impact of every qualification or adverse remark on the company's financial statement for circulation to the board before the same is passed on to the shareholder. There is amendment in section 143 suggested that enabling an auditor to prepare an impact statement for each qualification, reservation, or adverse remark on the company financial statement. Further recommendation on recognizing and providing enabling framework for the constitution of the risk management committees and clarifying the tenure of independent directors, and revisions revision providing provision relating to the disqualification and vacancies of the office of the director. And that is also ask invitation or invitation on for your comments or suggestion that the clarifying the procedure for resignation of the key managerial personnel, or strengthening the provision relating to the merger and amalgamation and ease of the restoration of the structure of company by enabling the regional director to allow restoration of the names of the company in certain instances. Recognizing a special purpose acquisition companies and allowing such companies which are incorporated in India to list on the permitted exchanges, providing on the conversion of cooperative society into a company, and strengthening the incorporation and governance framework for the Nidhi's company, and removing ambiguities from present provision under the Companies Act through changes of the drafting and consequential nature. There is the changes also recommended in the LLP Act for the incorporation of the producer limited liability partnership under the LLP Act to ease incorporation and compliance requirement for the producer organization. These are the summary of the company law committee report, which is invited for the comments or suggestion from the stakeholder through the e-consultation platform on the MCA website. In detail, we are covering our topic-wise analysis on our next video. Thank you so much for watching this update.